Good day everyone, good day ma'am. I'm Elaiza Taculod from base Section 3B, and right now I'm going to report the chapter 16 entitled Formalities of Entry in and Exit from the Philippines. So we have here the learning objectives. First is to identify various government requirements for foreigners to enter the Philippines and explain the importance of a valid passport when traveling and enumerate the privileges of Filipinos covered by the Balikbayan program, and lastly, discuss the dual citizenship law. The entry and admission of foreigners into the Philippines are matters of privilege because every foreign state has absolute and exclusive power of government in its own territory. Although entitled to all the rights and privileges of a friendly guest, they cannot claim the right to injure privileges which by their nature belong exclusively to the host. Unquestionably, every state has a fundamental right to the integrity of its territory and the exclusive and peaceable possession of its dominions, which it may guard and defend by all possible means against any attack. The international community leaves states at liberty to fix the conditions under which foreigners should be allowed to enter their territory. These conditions may be more or less convenient to foreigners, but they are a legitimate manifestation of territorial power and not contrary to law. And this chapter deals with the requirements of foreigners as well as Filipinos for entry in and exit from the Philippine territory. First, we're going to report is the admission requirements. The law, Section 10. Non-immigrants must present for admission into the Philippines an unexpired passports or official documents in the nature of passports issued by the government of the countries to which they owe allegiance, or other travel documents showing their origins and identity as prescribed by regulations, and valid passport visas granted by diplomatic or consular officers. Discussions of the law. Non-immigrants must present unexpired passports and valid visas prior to their admission into the Philippines. The Philippines Immigration Act provides 7 visa categories for non-immigrants, namely temporary visitor, transient, seaman, trader or treaty investor, foreign government official, student, and pre-arranged employment. An alien is allowed only one immigration visa category at any given time. Next, we have here also the admission of aliens under pre-arranged employment. For aliens who wish to engage in gainful employment in the Philippines, pre-arranged employment visas are secured from the Philippine Consular Office upon authorization issued by the Commissioner of Immigration. An applicant of a pre-arranged employment visa must prove the following jurisdictional facts: the Board of Commissioners and the nature of the labor or service for which the visa is desired. No person can be found in the Philippines who is willing and competent to perform such labor or service, and the length of time of employment and the wages of compensation to be received, and also the reason why no other person in the Philippines can be engaged for such labor or service, and certified copies of the contract of employment, and the reason why the admission of the applicant into the Philippines shall be beneficial to the public interest, and proof of his valid entry and admission in the Philippines. The Board of Commissioners shall also require the following documentary proof from the applicant. First is the qualification of the applicant, alien employment permit issued by the Department of Labor and Employment. In proper cases, a provisional permit to work or special work permit issued by the Bureau of Immigration. In certain cases, absence of derogatory information against the applicant from any local or international law enforcement agency, financial capability of the petitioning company to support and maintain the applicant during his employment in the Philippines, a written undertaking that the applicant shall not participate in any partisan political activity for the duration of his stay in the Philippines, a written undertaking that the applicant shall use the pre-arranged employment visa exclusively, certified copies of the corporate registration papers at the Securities and Exchange Commission, and proof of payment of the income taxes of the alien and his employer. And next, we have here the admission under the Balikbayan program. A Balikbayan shall mean a Filipino citizen who has been continuously out of the Philippines for a period of at least 1 year. A Filipino overseas worker or former or a former Filipino citizen and his family would have been naturalized in a foreign country and comes or returns to the Philippines, and those bearing foreign passport with the exception of restricted nationals shall be allowed, among others, visa-free entry to the Philippines for a period of 1 year. So we have here the Philippine immigration policy on non-immigrant Chinese. So shifts in Philippine foreign policy towards China in recent years have resulted in significant changes in immigration guidelines towards five major classes of Chinese, namely People's Republic of China (PROC), Special Administrative Region or SAR of Hong Kong, China, and of Macau, China, Certified of Identity Holders, and Republic of China, Taiwan, Taipei, Formosa. So they are now allowed under a temporary visitor or business visas with multiple entry visas for up to 6 months, and they may be even issued visas without prior authorization from the Department of Foreign Affairs, and provided they submit the following requirements and duly accomplish visa application form. Passport valid for 6 months beyond the period of authorized stay in the Philippines, and a valid entry visa to the next port of destination or re-entry to the country of origin or residence, and confirmed toward onward passage ticket, and such other requirements as may be deemed necessary with the consular officer. So Chinese are now allowed an initial stay of 59 days, whether for travel individually or in groups. Next is we have here the Philippine immigration policy on Indians. Temporary visitors visas are available to Indians nationals provided. First is they apply for a visa from their country of origin, or the NJ, or from their place of legal or permanent residence if they are no longer permanently residing in India. Those have been previously used a temporary visitor visa may apply for a visa from any Philippine embassy or consulate in a third country if they have not been subsequently denied a visitor's visa, blacklisted, or deported from the Philippines. We have here also the additional requirement prior to entry. For non-immigrants, a valid ticket for a return journey to the country of origin or to the next country of destination is required for presentation. Certificates of residence must be secured by the following categories of non-immigrants from the Bureau of Immigration: temporary visitors, students, and pre-arranged employment. Foreigners entering as non-immigrants may also be required to register in accordance to the provisions of the Alien Registration Acts as follows. First is any alien who is in the Philippines at the time of the approval of the Alien Registration Act and who is 14 years of age or more and will remain in the Philippines for 30 days or longer. Any alien who enters the Philippines after approval of Alien Registration Act of 1950 and who is 14 years of age or more who will remain in the Philippines for 30 days or longer, provided that this provision shall not apply to an alien admitted into the Philippines for 60 days or longer. So every parent or legal guardian of any alien child who is in the Philippines at the time of the approval of the Alien Registration Act of 1950 who is below 14 years of age and will remain in the Philippines for 30 days or longer. So every parent or legal guardian of any alien child who entered the Philippines after the approval of the said act and who is below 14 years of age and who will remain in the Philippines for 30 days or longer, provided, however, that this provision shall not apply to an alien child admitted into the Philippines as a temporary visitor or transit unless said child will remain in the Philippines for 60 days or more. So every parent or legal guardian of any alien child born in the Philippines whenever an alien attains his 14th birthday in the Philippines. Lastly, it is imperative of government medical officers, immigration officers, and the Board of Special Inquiry to conduct a sufficient medical examination of all aliens arriving in the Philippines. Such examination is focused on physical and mental health or may extend on the inquiry of the character of the arriving alien. Any alien who fails to meet the health and character standards established by immigration laws, rules, and regulations for entry and admission shall be excluded under Section 21 of the Immigration under Section 21 of Immigration Law. So extension of stay in the case of non-immigrant visa holders who stay in the Philippines will exceed 59 days, and the consular officer shall advise them that they should secure extensions of stay and register with the Bureau of Immigration and pay the necessary immigration fees. So the entry and admission of aliens are matters of privileges, and there is no ministerial duty of the part of the commissioner or immigration to extend the stay of a temporary visitor. So the power of the commissioner of immigration extend the stay of a temporary visitor is plenary. So he is vested with the power and authority to grant such extension. So therefore, the Secretary of Foreign Affairs is not authorized to admit into the Philippines aliens for temporary stay or to extend the temporary stay of alien visitors in this country, as the law vests such power in the Commissioner of Immigration. And lastly, we have here the Republic Act number 9/225, Dual Citizenship Law. Under this law, natural-born citizens of the Philippines who became citizens of another country shall be deemed not to have lost their Philippine citizenships. Consequently, they must file a petition under oath of the Commissioners of Immigration for the issuance of an identification certificate. Former natural-born citizens living abroad may file the petition to the nearest Philippine Foreign Post, and a copy of the birth certificate authenticated by the National Statistics Office is required to be submitted as proof of being a natural-born citizen of the Philippines. And that's the end of my report. Thank you and have a good day.